Hello, happy October 10th, 2025 from your friends here at PA Pardon Service, running the website recorderacer.net. Anna tells me that we're live streaming, whatever that means, but what we advertised and what we agreed to do was open our doors and sit here and be able to take questions from anybody about the pardon process. Especially what's currently going on the 8th, 9th, and 10th of this month, starting Wednesday, then Thursday, then Friday of this month. The Board of Pardons has reviewed 152 cases, and these are people that but they reviewed about 19 and so then the governor, hopefully within 3 to 6 months, issues the pardons that have been recommended to him. Once he issues the pardon, the Clean Slate statute that was passed last year tells the state police that they are to get a list of the cases that have been pardoned by the governor, and that they will be automatically expunged by the Pennsylvania State Police Expungement Unit. And so after that, there is a little bit of a question there about how you can actually verify whether that's been done or not, and I would suggest either using our service or contacting the Pennsylvania State Police Expungement Unit. Be prepared to have your date of birth and your OTNs, and you can ask them if your case has been expunged. And frankly, I would say, can you send me an affidavit of expungement? Because when you get the affidavit sent to you by email or any other way, you actually have something to hold in your hand, at which point many clients run to their local gun store and are happy to see that their Second Amendment rights have been restored. So the public sessions going on Wednesday, Thursday, and today is the next to final step in a very long, what's becoming a 3 to 4 to 5 year process, which is the only step remaining is for the governor to issue a pardon. The governor doesn't have to issue a pardon. In fact, occasionally he will just reject an applicant, and they're never required to give a reason, which is sort of frustrating. But 75% of the cases that the board reviews, they recommend to the governor. The governor's been signing 75% of the cases recommended to him. And that is why Pennsylvania has a truly effective, thriving conviction forgiveness process that, for all I know, is one of the best in the nation. So I don't know if we have anybody online. Oh. And I don't know if they have any questions. I hate to just sit here and blather about stuff.
Changed to one. I changed to one.
Okay. Yeah, okay. So here's a question. If someone had a conviction 10, 20, or even 30 years ago, why is it still showing up on background checks? So the answer to that is sort of complicated. I'm also just giving it my best reason to guess. But if somebody had a felony conviction in general, or even a misdemeanor conviction, they never went away. They never went away. Now, companies have policies maybe after 7 years or 10 years, they don't care about them. But the Pennsylvania Criminal Repository, where criminal records are kept, is almost like a credit report, and it never lapses. It's accurately showing what was charged back in the day. And so the general answer is criminal records, you can never count on them going away, although some companies stop caring about them after different periods of time. Then the legislature passed Clean Slate. The Clean Slate statute said that certain offenses should be sealed or hidden after 7 years for nonviolent misdemeanors and after 10 years for nonviolent felonies. The sealing removes some access to those records, but it doesn't make them go away. And so if your question is, well, first of all, how do you know if Clean Slate even went through automatically and sealed your record? And the answer is you don't, unless you write off to the state police to get a full access review. And then the other answer that I always have to remind people is that even if it has been hidden by Clean Slate, it's not gone. It still needs a pardon. Every sealed record is still a misdemeanor or a felony conviction that needs a pardon from the governor to make it truly go away. And so why is it still showing up on background checks is because the background checks are trying to be factually accurate. And meanwhile, there's some computer algorithms out there trying to hide things, and they're supposed to do this and they're supposed to do that. And sometimes they do and sometimes they don't. And so it's really the Wild West in terms of Pennsylvania criminal records. So if you have a conviction 10, 20, even 30 years ago, you're a good candidate for a pardon. The only other thing to keep in the back of your head is that if you hit the age of 70 and you have been off of any kind of parole or probation for over 10 years, you can proceed right to an expungement without going through the 4 to 6 year pardon process, because 70-year-olds are allowed to go right to expungements, file an expungement petition in a court of common pleas, and expunge that record in 3 to 6 months. That will expunge the Pennsylvania State Police criminal history. And then again, all of your rights come back. Let's have some more questions, or I might just start telling stories.
Yes, those rights.
What are the first steps someone should take if they're ready to clear their record? The first thing always to know is exactly what's on the record. Given what I just said about the Pennsylvania State Police criminal history, a great first step is to locate the PSP-170 form online. It's an Adobe PDF. It's a one-pager. It's very simple. And the person should fill it out with their first name, last name, date of birth, social security number, address, phone number, etc., and send it to the Pennsylvania State Police address that's on the SP-170, and include a photocopy of their driver's license. It will take a couple of weeks or sometimes a couple of months, but you will receive a Pennsylvania State Police criminal history, and in the top right corner will be a red stamp that says full access review. And that means that it is the deepest, most complete dive of the Pennsylvania records that you can have. And so when you are looking at that, then you're looking at hopefully your convictions. And what you want to do is analyze that report to see what can be cleared and when. This is, by the way, the modus operandi. This is the MO of Record Eraser. We find your record, we analyze it to see what can be cleared and when, and we give you a path. And the 3 paths are pardons, expungements, and clean slate petitions. So if you're looking at a nonviolent misdemeanor of a certain character and type that's over 7 years old, it can probably be hidden by clean slate within 3 to 6 months. But it still needs a pardon. So now you're going to start the pardon process, because Clean Slate hides it, but it doesn't expunge it. The pardon followed by an expungement is the true way to get rid of a misdemeanor or a felony conviction. But once we're looking at a record, if it's a nonviolent qualifying felony after 10 years, might be eligible for Clean Slate, local petition, probably for $900 plus or minus, but it's still going to need pardon from the governor, 4 to 6 years, that process. If you're looking at something where charges were brought on a docket and every single charge on that docket was withdrawn, dismissed, or null prost, that means that record is not a conviction. Now you can go to an expungement. You don't need to get a pardon for a non-conviction. You can just file an expungement petition, and in 3 to 6 months, that'll be gone and off your record, does not need a pardon. But then again, it's not a conviction. So sometimes when you're running into expungible cases, people will be like, I really don't care about that. I care about the felony and the misdemeanor right here. It's like, okay. They all require different, slightly different avenues to accomplish whatever it is you're trying to accomplish. So the first step to take is to find out exactly what's on your record. An alternative way, or an additional way, what we do is both. We write to the clerks of court in the county of conviction, if that is known, and ask them for somebody's records. Now you'll get the county records. We also write off to the Pennsylvania State Police for that full access review. Now you can match these two up against each other. You can see what can be cleared and when. Couple more little things about what is expungible. A summary offense after 5 years of law-abiding behavior is expungible, 3 to 6 months in the county of conviction. An underage drinking citation can be expunged by petition in the county of conviction after you reach the age of 21 without waiting 5 years. It's another rule. Juvenile records, juvenile convictions can be expunged in the county of adjudication. And a lot of first offense DUIs get ARD. ARD is a diversionary program that it allows that record to be expunged once you've satisfactorily completed all the requirements of ARD. That is not a conviction that can be expunged. So hopefully you can see how you really need, I mean, to us, criminal records are like the X-ray. If we're the surgeons trying to remove criminal records by legal surgery, the first thing we want to do is have an accurate X-ray about exactly what we're dealing with. And by the way, all of my comments only pertain to Pennsylvania convictions. If you have convictions in another state, they need to be cleared in that other state. Pennsylvania cannot clear another state's charges, and a background check will continue to go to, either the FBI or wherever, which would pull records from all 50 states in case you have convictions in multiple jurisdictions. So that's a little overview of what can be cleared and when with pardons, expungements, and clean slate. And now, a word from our sponsor. We don't have one. we just do this stuff nonstop every day, day after day. Because I started in 1988 with a law degree, and I joined the public defenders in Lancaster County. And for 3 years, I defended hundreds of people and also hundreds or thousands of juveniles. And then in 1991, Judge Maddenspacher hired me to become a Lancaster County Assistant District Attorney when they were actually rolling out the first computer system. And he wanted me to help implement it since I was a computer consultant at the time. And so for the next 7 years, I installed computers and prosecuted a full slate of adult criminals and also prosecuted a full slate of Lancaster's juvenile delinquents, always with an eye towards being fair and impartial and trying to do justice, but nonetheless prosecuting. And then in 1998, I left the district attorney's office and opened up my own law firm, which started off as Walmer Law up in Mount Joy. And then I was put on Lancaster County's court-appointed complex felony conflict list, which is a lot of words, meaning if the public defender has one co-defendant, they can't represent the other co-defendants. And so these other conflict attorneys get assigned the cases and get paid by the court to defend or go to trial. This includes murders, robberies, arson, everything, absolutely everything, capital homicides. And I did that from 1999 to virtually 2015, 2020, but right around the same time as COVID, slightly after. I stopped going to court. I pivoted. I had been filing pardons and expungements all throughout Lancaster and maybe Pennsylvania for years, but I had accidentally sat through tens of thousands of guilty pleas being given out, and it just started to creep into my awareness of how debilitating these convictions are. These convictions, like the first question today, somebody's been dealing with a conviction for 10, 20, or even 30 years. You won't believe how many people I talk to every day that says they're having trouble finding work for something that happened 10 years ago. What are they doing? How are they living? I try to refer them to career links. I try to refer them to different hiring sectors, which might not be where they want to work, but it might be where they don't care if you have a felony conviction. I think tow truck drivers or even skid loaders in warehouses, I don't think they care about a felony conviction. I'm not sure. I know agricultural workers might not care. Construction workers might not care. I also know people, a good portion of my clients, that were basically forced to start their own businesses. So they learned a trade like electrical, and they became electricians. And then they would start their own business and they would hire additional subcontractors. And you know what? If you're hiring yourself, you're allowed to interview yourself and you don't have to care about a felony conviction. Now, what seems to happen is when you want bigger jobs, or when you want to go to a high school to install electric, or you want to go to a government facility, you're going to find limitations, because even if the owner is the owner, if he has a felony conviction, the bases and the high schools are going to want to see a background check. And then those electrical jobs or those plumbing jobs or those vo-tech jobs are going to go to somebody else. So that's just part of the doom and that these convictions give out. And in fact, you know, if you look at this list of 152 people, and the convictions range from 5 years ago to literally 30 years ago, 150 people in just this session alone have been disempowered, had their earnings flattened, had their lives changed for 10, 20, 30 years, 150 people. And the board will review at least 3 more lists like this for a total throughput of somewhere between 450 and 500 cases a year, and have thousands of people waiting behind them in the queue. And all of these people, to a certain extent, have been struggling financially, or been judged in the community, or been embarrassed at church, or aren't allowed to go to their kids' soccer game, or aren't allowed to go to the field trips with their kids. So maybe to the few of us who are watching, or maybe one of the things I'll start standing on a soapbox about is encouraging people to talk to their local representatives, your political representatives, and just acquaint them with some of the horror stories about how debilitating these criminal records are that just keep giving time after time after time. A lot of people, this is a question, a lot of people think a pardon equals automatic erasure. Is that true? Let's be very, very specific, because the answer is yes. If in fact a pardon is what was needed, and if in fact a pardon was granted by the governor, then the state police will automatically expunge that record, which I believe is what's meant here by erasure. So yes, a pardon does equal automatic erasure / expungement. It used to be, until about a year ago, if you got a pardon from the governor, each attorney needed to file a petition to expunge every docket that was on that pardon, which could lead to legal fees, again, of thousands of dollars. The Clean Slate law is what passed last year, is the one that implemented the fact that the Pennsylvania State Police are to automatically expunge everybody the governor pardons, once they send him a list of who's on the list. And the state police have been doing that regularly and reliably. It took them a while to step up to the plate, but now, to my opinion, they're doing it very well. Story. Well, I should really keep track of my interviews during the week and make some notes about what was going on with them. Well, here's one I just heard today. Guy was at a bar and offered to give his buddy, I think, and his brother a ride home. And so he's driving them home, and at some point he stopped to get out at 3 o'clock in the morning and take a leak beside his car, which is a famous way to get pulled over, because if the police see you taking a leak in public, you're going to get investigated. I think they were investigating him then for a DUI, but they wanted to look in the car, and he was like, sure, go ahead. And they looked in the car, and that's when they found out whoever had been in the back seat had left a bag of pot. The police typically believe that the driver of the car is responsible for everything in the car, which is not technically true. And the reason for that, I'll bore you with the legal reason, unless somebody asks more questions, is because constructive possession, if you don't have the thing on you, if you possess it, you possess it. But if it's not on you, constructive possession requires two things. You have the ability to control it. And would a driver be able to control a bag in the back seat if he knew it was there? Sure. But it also requires the intent to control it. And does a driver who doesn't know a bag's in the back seat of the car intend to control that bag? No. Actually, you know who intended to control it? The police. The police took possession of it. But then they charged the driver. That's part one of the tragedy. Then this guy goes to court, and he's given the opportunity by the police to tell them whose bag it was, and the police would have charged both of them still anyway. But he didn't want to give up his brother, so he didn't. He just said, I'll take the fall. So they charged him. Now, what they did was they charged him with a felony instead of a misdemeanor. Misdemeanor possession, felony possession with intent to deliver. That's easily a call that the cops can make, but again, it requires certain elements of proof to say somebody was going to deliver a bag in his back seat. But they brought the felony charge, and then what happens is you go to court, the district attorney picks up the case from the cop. The cop says, hey, he didn't cooperate at all. He wouldn't tell us who his co-defendant was. And then the DA's like, no deals, no deals. I have you, and I'm going to squeeze you. And so then the defense attorney gets involved, and then the district attorney says, well, I'm going to threaten you with state prison unless you take a plea. And frankly, I don't think they'd be able to prove the guy possessed it at all. But if you want to go to trial to prove you didn't possess it, you have to pay your lawyer for a trial lawyer, or you need to convince a public defender to go to trial. And then it is true that there's a trial tax, and that if you go to trial and you lose, you will probably get a more severe sentence than if you accepted a guilty plea, because the guilty plea is supposed to be a slightly moderated offer to induce you into pleading guilty and giving up your rights. But at the same time, in this particular case, the DA said, well, if he goes to trial and loses, I'm going to try to send him upstate. But if he just takes the plea, he can have 6 months in the county or probation or whatever. And so the defendant is sitting there saying, I have these constitutional rights. I know I didn't know anything about it. I have a lawyer that's saying, give me, $2 to $5 grand to go to trial. I have an offer for either probation or a local county jail sentence that I can do work release and keep my job. or I can pay the lawyer $3,000 to $5,000. I could still lose, and I could be sent up to state prison. Which of those options gives the defendant more control? Well, the plea does, and that's why over 95% of all cases end in a guilty plea. The system would not be able to work or conduct trials if even half the people wanted them. But the system is set up very efficiently through every professional involved, from the police to the county detectives to the district attorney to the defense attorney to the judge. And by the way, judges, I assume everybody knows this, judges on the Court of Common Pleas are all judges, or they are all lawyers that get elected to serve as elected judges. Magisterial district judges are not all lawyers. Some of them are elected representatives in the community. Some of them were constables that got elected. Some of them were former police officers that got elected. Some of them are just political people that got elected. Once they're elected, they become a district judge. What if someone was charged but not convicted? Do they still need a pardon? No, pardons are for misdemeanor and felony convictions. They are not for if someone was charged but not convicted. If they were charged but not convicted, there's two scenarios at least when that happens. As I said earlier, if the charges were withdrawn, null prost, or dismissed, and there is no conviction on that record, it can go right to an expungement, 3 to 6 months in the county of non-conviction. That can be completely erased off the record because it was charged but not convicted. That's one scenario. The other scenario is, in fact, this happens occasionally, a guy called me about a 10-year-old charge to talk to me about a pardon. And I looked at the charge and I pulled up the docket sheet. This was a guy who I think was visiting from out of state, and he was in Allegheny County, and he picked up a charge from 10 years ago. Now, he had other things that he needed a pardon for, but when we were talking about that one, I said, dude, that's still an open charge. That charge turned into a bench warrant. 10 years ago, when you went back to your state, you never responded to a summons or a subpoena for this, I don't know what it was, a DUI, I think. And what the system does anytime you don't show up for court, it issues a bench warrant. A bench warrant is like a big timeout. It just tolls all tolling of all time. It tolls the statute of limitation. It tolls everything. And so I ended up telling him, I think I sent him to an attorney in my referral network, you need to hire a Allegheny County criminal defense attorney to see if you can make that charge go away. And then two sub-issues will come up because I've done this in Lancaster County. One issue is, can you make it go away completely without me coming back to Pennsylvania? Let's say he lives in Utah or something and he really doesn't want to come back. One question for the defense attorney is, can you call up the DA, say he's been missing? Can you convince the DA that this case should just be thrown out or null prost because the guy wants to get a pardon? And then the district attorney has the ability to say, no. He can't hide from the jurisdiction of the court for 10 years and then expect special consideration. He can't expect special favors. I might have been willing to throw this case out back in the day, but right now he has to come back and surrender to the warrant. Okay, there's a little term of art for you. Surrender to the warrant. In Lancaster County, that means I would talk to the sheriffs, talk to whoever's running the bench warrant court. The guy would show up at 11:30 in the morning. He would get taken into custody by the Lancaster County Sheriff's Department, and then they would put him, with my help, on the 1:30 call of the list, or the bench warrant list, and then he would sit for an hour or two on a metal bench. Then he would get called into court, and the judge would have a chance to talk to him and me about, where were you? Why weren't you here? Why didn't you know there was a bench warrant? And then hopefully, if you have good reasons and your attorney does a good job, the bench warrant is lifted. Your bail is either set at ROR or reinstated. By the way, the phrase is ROR. It's release on recognizance, which means you're being released on your own promise to show up. It's ROR. I hear RNR. I hear R. It's ROR, released on recognizance. And so then there's the second part of the question, which is, okay, hopefully you're out of jail. Hopefully you have bail. Now I can start talking to the DA about whether he really wants to prosecute this 10-year-old DUI. And it could go either way. A good attorney and a reasonable DA would manage to make that case go away. Now the door opens to the pardon because there's no recent conviction. And so that is the golden path. The alternative is the attorney can't make it go away. They still have the officer. They still have the testimony. They still have the proof. And the DA wants a conviction and isn't willing to plead it down to a summary or something. Plus, don't forget, this guy's still visiting from Utah. He wants to wrap this up as quickly as he can, and that gives the district attorney a lot of leverage to take a guilty plea out of a guy. And then you have a brand new conviction. Does that affect the pardon? Sure. Does it say you can't file for the pardon on the older stuff? No.
Don't forget, this guy's still...
Does it somewhat complicated because now there's a new conviction that would have to be explained to the Board of Pardons? Yes. Is the fact that the conviction's recent only because you didn't know about it 10 years ago? How does that factor in? Plus, the Pardon Board, just from sitting through the most recent round of hearings, they frequently ask questions like, how did you not know you had a bench warrant? Did you know you got stopped by the police that night? Well, yeah. And so then you went back to Utah? Yes. How did you not think to check to see if Pennsylvania had a case against you? Well, I just went back to Utah and resumed my life. I figured it all blew over. I figure it all blew past. I figure it just went away. The criminal system is not set up to just let things go away. Things don't go away. They turn into bench warrants at the first listing of the case where the defendant doesn't show up. And as I said, that's the big timeout. That's the tolling. Everybody sits tight. What if someone was charged but not convicted? Do they still need a pardon? I did that. I answered that. Someone said they're all in on it. Well, we're back to the amazing complexity of criminal law, co-defendants in a car getting pulled over, and the police are taught immediately to separate everybody to different corners of the car. Hopefully they have enough police officers to talk to them all individually because they don't want you to hear the other person's story. Then they figure out who's making up a story and they confront him with the other person's story. And then they offer to give that guy a better deal than the other guys. And then they tell them, look, and they lie to you too. Hey, Tom just told me exactly what's going on. Do you want to get in on that? Or do you want to be treated more harshly than everybody else? Well, no, if Tom told you what's going on, I'll confirm what he told you. Tom never told him anything. They went to a class and learned how to lie to defendants to get them to offer up incriminating evidence. And along this course of investigating and talking to different people, somebody said they're all in on it. Or actually, they're all in on it. Sounds like something the police would say to the district attorney. They're all in on it. If you're actually a good lawyer, you want to know exactly what that phrase means. Who is they? Are there 4 people? Yes. Show me where all 4 of them said they were in on it. Well, 2 of them did and the other 2 didn't deny it. Okay. Well, then you don't have they're all in on it. You have 2 people said they're responsible. 2 people didn't make a statement. So it's really fascinating work. It's really fascinating work to the extent that a defense attorney or a prosecutor, you have the criminal law, you have the statute. The statute tells you the elements you need to prove beyond a reasonable doubt in order to get or avoid a conviction. So you start with the crime, you know the law. Now you have witnesses, you have statements, you have evidence, you have police officers, you have searches. Was the search legal? Was it illegal? What if the evidence is suppressed? Do you still have witnesses and enough stuff to prove the elements of the offense? So that's sort of fascinating to the lawyers who are sort of bookish and nerdish, because you at least develop a theory of what the Commonwealth has to prove, and then you find a way to try to undo that or untie that or raise reasonable doubt. So in an academic sense, whether you're a prosecutor or a defense attorney, it's interesting, fascinating work. The devil is that every one of those details is a witness who's had their lives affected by the police, who's been inconvenienced by an interrogation, who has had their evening disrupted by the search of a car, is probably facing a possible conviction and facing a life-changing, devastating event affecting their employment, housing, and education for the foreseeable future. So I'm aware of the fact that on one hand, I guess it's sort of back to the surgical analogy. On one hand, you start with the x-ray, you know what you need to do, and it's interesting work if you separate yourself from the people. But at the same time, at the end of the surgery, there's going to be somebody that's going to be lucky to live or walk with a limp the rest of their life, or else have one leg shorter than the other, or else have to go on unemployment and workers' comp for, 5 years, or you have a criminal defendant that is told by probation and parole, this is what's on your record, go out and get a job, pay your fines and costs. If you don't, you can be put back in jail, etc. You know how it rolls. 10 minutes. Gun restoration and knowing what is on your record, highlighting yesterday's attorney error when finding their criminal records. So that was a note from Anna to me, and she's absolutely correct, but I don't know where that 4473 form is. What we went over briefly yesterday was the fact that somebody had an old, let's call it a 10-year-old nonviolent misdemeanor or felony, and was talking, he went to a pardon clinic, thank you. He went to a pardon clinic, which is one of these free nonprofit clinics that various agencies sponsor around the various counties. And that attorney, who may or may not have been a criminal lawyer, he may have been a civil lawyer that just agreed to help out, to help the people in his community. They may or may not be an expert at criminal records and reading them. They may or may not know about Clean Slate and its record hiding consequences. But in any case, that attorney did a quick look for the record on the UJS portal and did not find it, and told my client, you don't have a record. I don't see a felony. Well, when you say something like that to a regular guy, he hears, I don't have a felony. I don't have a record. So what'd he do? He went to a gun store and started filling out the U.S. Department of Justice Alcohol, Tobacco, Firearms, and Explosive 4473 form. And question 11C is, have you ever been convicted of a felony or any other crime for which the judge could have imprisoned you for more than 1 year, even if you received a shorter sentence, including probation? And as I pointed out the other day, the part of that is just ridiculous is that unless you're a criminal attorney, you don't know what crime the judge could have imprisoned you for more than a year, even if you received a shorter sentence. And as I explained, a misdemeanor 3 is only punishable by the maximum of up to a year in jail. So an M3 is not disqualifying. An M2, you could be sentenced to 1 to 2 years in jail, and that is certainly a sentence of more, well, could you have been in prison for more than 1 if your sentence is 1 to 2? Technically, yes, but the average person isn't going to know that. And certainly every misdemeanor 1 or higher, misdemeanor 1s are punishable by a maximum of 5 years. And so clearly from M1 to felony 3 to felony 2 to felony 1, those are disqualifying. But even some police officers don't know any crime for which the judge could have imprisoned you for more than 1 year. You know what? What if you were disorderly in a park, or you were skidding your car around in a parking lot and a whole bunch of people were watching during one of these drag swaps, these drag meets or something like that? What if you got written up for 5 disorderly conducts? Disorderly conduct for each person that you could have hit. Summary offense, very small. Maximum fine, $300. Maximum jail, 3 months. Okay, so right, I'm spitballing here. I'm making up a weird analogy. But if a judge wanted to, he could give you 1 year and 3 months on those 5 summary offenses by giving you 3 months on each one consecutive. 3 months on one, 6 months on two, 9 months on three, 12 months on four, 15 months on number 5. So there's summary offenses for which the judge could have imprisoned you for more than 1 year. Nobody knows that unless you've been in the trenches. Now, this particular person that was told by the lawyer that his felony had gone away or he couldn't find it, what actually happened was the Clean Slate algorithm went through the database and it hid or sealed or hid a nonviolent felony like it's supposed to. The lawyer's mistake was not, number one, saying, I don't know if it's still there or not. If you know you had a felony, it's still there. Number two, not knowing how to request a PSP 170 to get Pennsylvania State Police to show you what's actually on the record. And number three, helping the client to believe he didn't have a record, because when he filled out this form wrong and he went to get a gun, the police showed up at his house within the next couple of days and basically charged him with unsworn falsification. And he should not have pled guilty to that, but he did. The reason he should not have pled guilty to it is that nobody can understand this sentence. And in Lancaster County for years, if you're charged with a crime like that, the district attorneys and I were able to get them ARD, probation without conviction. You should have known maybe that you did something wrong, but it's not worth a brand new conviction. Give us 6 months to a year of probation and the charge will be dismissed. It can be expunged. That's a reasonable workout. But anyway, that's just a little sidebar about gun restoration. Actually, I guess to put a pin on it, your rights are fully restored when your disqualifying offense has been pardoned by the governor and then expunged by the state police with confirmation that you can prove by having an affidavit of expungement. Then your gun rights will be restored if Pennsylvania was the only state you're talking about having a record in. If you have convictions in other states, I can't advise. And so that's that. And we are running at about 40 minutes. If there's any other questions, I'd be happy to stay. Otherwise,
The tingy one.
I have a question. Someone said, I had my hearing on Wednesday, 9 a.m. My internet stopped working before I could see the vote. Is there a place I can find that by chance? So I would say that you could write off or you could call the Board of Pardons. They do have a phone number. They do take phone messages. They are responsive. And in fact, there were a number of technical glitches that happened Wednesday, Thursday, and Friday. Last night they were having glitches. The board went off and they came back to do their vote. When they came back to vote, it was just glitchy and we couldn't even listen for part of it. So you have to ask the Board of Pardons. They're very nice. Tell them your internet stopped working. Give them your phone number and ask them to tell you what the vote is. Also, I can tell you that they will follow up with a letter or an email. You will receive written confirmation of what the vote is, but obviously it takes a week or two to get that. So that was a really good question. Spot on. And if that's everybody's questions about pardons, expungements, clean slate, and criminal law, I am going to start doing a separate sort of podcast or video channel about stories because these stories are actually horrible. They're debilitating, but I think people would like to hear them. I'm afraid that some of the legislature and regular everyday Americans don't really realize what the people in their communities are dealing with when they get a criminal conviction, even just for having a joint, even just for getting high when you were in high school. So we'll start promoting that too. Maybe that'll be like a call in or something. But anyway, whoever's here, thank you. Spread the word. Subscribe to my channel. All we do is post content about Pennsylvania pardons, expungements, and clean slate. And now for the afternoon session, public sessions of the Board of Pardons.